You hear me? Oh, good. No, but I have so much to tell about you in the meantime. So, Deb's expertise focuses on global and Israeli cybersecurity law and regulation. Her law practice advises clients on high-level strategies for legal planning and regulatory compliance with these fields. She teaches Israeli and international cyber law at the Law Faculty of Hebrew University and the Herzliya IDC, and is a guest lecturer at the Harvard Kennedy School's Exec Ed program on cybersecurity. Do you want me to continue? Oh, yeah, I still have time.
4 kids.
Oh, 4 kids. Oh, my God. Deb's experience at the international level includes her participation as a member of the international group of experts that drafted the Tallinn 2.0 manual on state activity in cyberspace, and as a member of the ILA's study group on cybersecurity, terrorism, and international law. So she'll be focusing on cyberspace shutdowns by states, whether of the internet, mobile telephony, or other cyber-enabled communication networks, and the applicability of these state activities of the international telecommunications law regime of the ITU. Good luck.
So all that was just to give enough time to get everything going, right?
It's better than commercial, isn't it?
So we're talking about the kill switch problem, right? So 2 months ago, when Catalonia was going through a few wrenching weeks of its referendum to separate from Spain, the media was filled with reports of the political struggle of Catalonians against the Spanish government, some of them anyway, and the upcoming balloting. What was much less covered in the media, at least in Israel, was the fact that the Spanish government cut off internet and wireless communications all around the areas of the voting. And in fact, on the day of balloting, Spain cut off internet connections all around the balloting areas so that votes could not be transmitted by internet for final counting. Full access to communications networks by Spain, who actually operated who was in charge of the Catalonian communications operators, only happened after the elections. Spain and Catalonia are not alone. The Ethiopian government, over the course of the past year, has in fact cut off cell phone and internet as a result of the activities of human rights activists, online and offline, disturbances in various areas that were located far from the government, so internet and cell phone cut off in those areas. And perhaps most interestingly, for the matriculation exams of Ethiopian students at the end of their school year in 2016, complete internet shutdown throughout the entire country of Ethiopia. Now, this happens quite a lot actually in India around matric exams, but it happens locally. Ethiopia shut down the entire national internet so that students wouldn't cheat on the matriculation exams. Maybe it's not a bad idea, but it's the use of a kill switch that we need to take a look at. You may take this lightly. The US State Department did not take it lightly. It issued a travel warning in August 2017, you can see it here, that the government of Ethiopia has demonstrated its ability and willingness to restrict or shut down internet, cell data and phone services, et cetera, et cetera. This was seen as a difficulty for providing consular services to US citizens in the country. I raise a question as to whether the rest of the notice said what, but keep your cell phones on. Wasn't sure where the US State Department was going with that. But here we have really interesting evidence that governments care when internet shutdowns take place in other countries anyway. So we're in a Houston moment. As in Houston, we have a problem. More and more governments are using their authority to cut off communications in cyberspace. And they do this in a manner that's not transparent and it's unilateral. And it doesn't give citizens or other governments, as a matter of fact, the opportunity to oppose these steps, perhaps protest them and preempt them. The instance we all know about is the January 2017 cutoff of Egyptian internet by President Mubarak in the wake of the Tahrir protests, but there are many, many hundreds of other cutoffs. We have a great chart put together by the Brookings Institute that goes up to 2010 with we can see the line, which sort of reminds me of the internet interconnectedness, the sort of access to the internet line, sort of the same the same curve, although I'm not a statistician. And the Brookings Institution is keeping track of these cutoffs. They're available on their website. And there's also a civilian sector organization called #KeepItOn that's also doing tracking. You can also sort of register any information you have about cutoffs. So this is to the tune of $2.4 billion per year for the 2016 year, according to the Brookings Institution. Tahrir Square alone cost $90 million to Egypt. But we're not economists, we're lawyers. What I'd like to do in the very few minutes that we have is to explore with you this phenomenon of government kill switch use. And not only from the point of view of international human rights, but also from the point of view of a much less looked at branch of law, which is international telecommunications law. And we'll see whether what the ramifications are. I'm going to propose for the concept or the idea that some of the longstanding norms of international telecommunications law, which we're going to call ITL for short, can serve to buttress or bolster the exercise of human rights in cyberspace, in particular the freedom of communication. It's not a replacement for it, but I think it does add a little piece of, a little bit of a strengthening nudge to the applicability of human rights law in cyberspace. So let's see how that works. First, some definitions. What do we mean when we're talking about this use of kill switches? What's inside the scope and what's outside of it? So the issue isn't only internet shutdowns, right? We have to think a little bit more broadly. We mean an intentional disruption by a state, actually I can read it, an intentional disruption by a state to communications through cyberspace. And that's very broad. So it's internet, it's GPS, it's cell phone communications, it's regular phone or fax lines, and I'll have an interesting Israeli example in a few minutes about the fax line piece. Satellite imagery. So journalists use on a regular basis satellite imagery to, as part of their stories, as part of their coverage. Governments use something called shutter control to cut off to cut off those communications so that journalists can't use pictures. It's a technology neutral phenomenon. So we're looking at the entire sort of realm of telecommunications or cyber-enabled communications, which the ITU, the International Telecommunications Union, describes or defines as, in this sort of complicated text, pretty much anything that goes through a pipe or that goes through the electromagnetic spectrum that is communicated over interstate lines. Okay, so it's a little bit of an antiquated definition, but it's very, very broad in scope. What are we not talking about today? Or at least in these few minutes, we're not talking about the content of speech. So this isn't a content regulation discussion. It's not even a discussion about cutting off certain websites. It's really a discussion about, or an investigation into how digital communications infrastructure may be cut off by governments and what the rules are. So, ITL. This is the symbol of the International Telecommunication Union. A treaty regime that's long-standing. It was founded in 1865. We'll see an example of its first, what that first treaty looked like in a second. The first intergovernmental organization ever. It preceded, for example, the Universal Postal Union by about a decade.
It was not called telecommunications.
It was not, as we will see in the next slides. It was called the International Telegraph Union because it dealt with telegraphs. We'll see that in a second. It's now a UN specialized agency, and what's important in terms of our legal analysis is that every state in the world is a member. So we have members, 123 member states, really universal adoption of the treaty law here. And what it deals with, what the ITU does when it wakes up in the morning, is it deals with telecommunications infrastructures. I'm saying this a few times, so it'll go through. This is what we mean. We mean the pipes. We mean the plumbing of cyberspace, right? So everything you're seeing, these are undersea cables, satellites, computer networks, mobile cell phones. We're talking about the pipes. And the purpose is just to kind of refresh our memories about what the constitution of the ITU does. It really talks about, or it really addresses states' resolve to ensure the easy, fast, efficient transmission of communications across state borders. It's got to be efficient, it's got to be useful. There's a sort of vague finger direction of making these services and infrastructures available to the public. Probably not a human right, but if in sort of a more modern sense, under the WTO and other resolutions. They hold universal service, universal access provisions in more economic contexts. That's sort of where it's coming from. So, Yuval, to follow up on your point, indeed, in 1865, it was not called the International Telecommunications Union. It was called the International Telegraphic Union. This is you people that are sort of, the tens of people in the room are probably among the only people in the world, possibly the universe, who've actually read now the first article of the 1865 Paris Telegraphy Accord. It was signed onto by 16 Western European countries because they wanted to make sure that the telegraph network, if you will, would work in a harmonious, efficient, and way that allowed instantaneous communications, or instantaneous in those terms, in terms of the 19th century. So this is the starting point. It's translated here, so to ensure rapid transmission of telegraph messages, but really the same norm exists in 2014 version of the ITU Constitution. Sorry, I'll let you read that. So the modernized version of that whole telegraph enabling agreement was to, it reflects the willingness of member states, or the resolve of member states, to ensure the establishment of, I'm sorry, there we go. To ensure the establishment under the best technical conditions of installations of infrastructure, so that the rapid and uninterrupted exchange of telecom and cyber-enabled communications can take place. So the obligations are obligations of conduct, not of result. States need to ensure establishment of the infrastructure, they need to maintain it, they need to safeguard it. So that's number one, put the infrastructure in place so that even before we get to the exercise of the human right, you've got a way to exercise it. Articles 34 and 35 are the ones we're going to really sort of focus on. Article 34 recognizes the sovereign right of states to stop telecommunications. Don't get stuck on the first paragraph, which talks about telegrams, any other private telecoms. So again, telecoms being equivalent, more or less, to any cyber-enabled communications. So states, in principle, need to allow the fast transmission of these kinds of communications, but they're allowed to stop them. According to principles, take a look at these: dangerous to the security of the state, contrary to its laws, to public order or decency, sort of an echo of Article 19.3 and the considerations under which you can stop, under human rights law, communications can be interrupted. So that's sort of a parallel echo. I'm not sure there was a firm coordination between drafters, but that's the way it worked out. So states do have, under ITL, the authority to stop communications. However, the following article, Article 35, we see that when this stoppage of communications, as in the use of kill switches, affects other countries, as in modern cyberspace, and in our cyberspace and through the use of the internet, it nearly inevitably does, there is an obligation on the part of the states to notify the international community. So the way this notification is set up under ITL is send in a telegram, send in a letter, send in an email to the International Telecommunications Secretariat, and we will let everybody know. Okay? And we'll look at sort of at the end of the next few minutes, we'll look at how that might change. But there is an obligation, if you're going to use your kill switch, if I could translate it into what I want to get to let the world know ahead of time. Note that it's an immediate obligation. So states can't go rogue with kill switches. They've got to let the world know, they've got to let their populations know. And 5 to go? No. It's easy in a room like this to say, okay, we've got an obligation on the page. States either do it or they don't do it, but it's a standing legal obligation. But we didn't stop there. So last week, or 2 weeks ago, or 6 months ago, called the legal advisor of the ITU, and I said, does this really happen? And his answer was, all the time. States do this all the time. They notify the ITU, which immediately notifies all member states, so the whole world pretty much, electronically. In the olden days when telegram services were interrupted, VoIP services interrupted, collect calls interrupted, all this whole list, types of communications to ships in port. certain countries. This will be familiar to many of us in the room. So this is one of tens of examples of the United Arab Emirates saying, collect calls to mobile numbers aren't expected, and P.S., no cyber communications to Israel. So this happens. This is a recent example, just so you can see sort of what a notification looks like. This was a notification from 2013 to stop text services. This is one from last month. Nepal put in a notification that we're not supposed to, hasn't been published yet to the whole world. It's been published on the ITU website, but it hasn't gone out officially. And I just wanted to note really quickly, in small letters, who remembers the LSM case from 1988, from the first Intifada? Well, you may remember this. So Israel had this Israel reported to the ITU about the interruption of fax services to Judea and Samaria, to the Palestinian population there, under the following circumstances. First Intifada, Tunis, the PLO operations center in Tunis, was faxing operations orders to Judea and Samaria, and that was how the first Intifada was actually being played out, through fax orders. So the IDF obviously found out about this at an early stage, and before they cut off the fax lines to Judea and Samaria, they sent in a notice to the ITU and said, we're going to stop these communications. So that actually happened. Then there was the High Court of Justice got an atira, a claim, a petition from a human rights organization, Palestinians whose fax lines had been cut off. And their petition was denied, but there was actually a substantive discussion in the Israeli HCJ on the right to communicate under the international law of occupation and under ITL law. So that's sort of an interesting kind of corner of the history that ties in. 2 minutes or 1 minute. So what are the ramifications? Where do we want to take this? Two things. First of all, ITL, I'm convinced, establishes a state obligation of notification. It's a transparency obligation. It's an immediate transparency obligation. It applies without prejudice to the substantive human rights issue. So there is a right, isn't a right, but even before you get to that weighing those considerations, you need to notify if you're a state that's going to use a kill switch. Now there is a view, or views, that say that although the ITL regime is longstanding and robust and supported by state practice, the original intent of states in the times of telegraphs, as you've all mentioned, is no longer appropriate in cyberspace. We're in a whole different world. And this sort of goes to Neva's point as well, that we need to be thinking in a forward way rather than in a backward way. But I'm going to argue here for a middle ground. And that is, as Professor Schmidt has written recently regarding the gray zones, and I kept the E instead of the A, so gray. This legal ambiguity is hobbling state responses, not contributing to it. And here's an opportunity, I think, to reduce a little bit of the ambiguity. If the problem we're trying to solve is to reduce the cavalier use by states of kill switches and move ahead with the enforcement of freedom of expression in cyberspace, this regime, as old as it is, provides a very clear norm that's supported by state practice, has never been contested, and continues to be applied on a regular basis. So the use of kill switches and stoppage of other communications through cyberspace, it should also be subject, I think, to this transparency requirement. It isn't right now. It needs a lot of tweaks. And in the end, what it does is it really nudges things. If implemented, it will nudge forward. This is not a revolution. It's a nudge. Some further issues that I'd like to explore that maybe we can have some questions on. The role of the private sector's actors here. So what's the responsibility of an internet service supplier when it receives an order to implement a kill switch? Should it or should it not? What should the criteria be? And then just to conclude, a broader examination of ITL norms in the cyberspace context. Where do we go with old established norms that have a lot of state practice backing them when we move into a new cyberspace context? Thank you.
Thank you so